These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Alrighty. Today, or this weekend, we will be covering comprehensive administrative processes. We're going to go into a lot of details around private contracting. Because of that, we want to give a firm foundation in the private-public trust so that you have a clear understanding of your role in your relationships with the parties you're contracting with. It's absolutely essential to mastering your process. So what we would, I want to go over maxims and the private-public trust. Is there a preferred order?
Yeah, why don't we go ahead and get them started with, we'll let you take it over, let you introduce a little bit so you getting your orientation, so when you start talking about public and private, you might have a little better understanding of it. Who are you? Because Jack and Brandon and I have talked about that extensively, and until you know who you are, besides just giving lip service, I'm me, I know who I am, do you really know who you are? But who is you? We had a talk last night. Alina, come up here, Richard. We have here a 10-year-old who's very interesting, and she's been doing some studies with her father. And her discussion is, we had a little discussion last night, so we might ask. I'm going to ask you, who are you?
Why do you want to ask me this question?
I just want to know who you are.
I'm Alina.
Are you sure? Do you have a social security number? Or does Alina have a social security number?
Alina don't have a social security number.
And does Alina have a name? Or do you have a name? Or do you have a lot of names?
Well, I have a lot of names.
Ah, there it is. And in the most basic sense, who are you? Can you help me with that? It's like, who are you? Are you that spirit in this body?
Yes, I'm a free person.
Aha. Okay, thanks. Go ahead, sit down. Not trouble. It's important for you to articulate. Try and put it in some basics. We sometimes open up, or I speak with my students and I say, I don't know if you can answer these 4 questions. Who you are, who you aren't, where you live, and what your country is. I talk to a lot of lay people this way. So if I say, who are you? Well, let us get this down. We need you to get some basic materials to work with, everybody out there. I would highly recommend you get a Webster's 4th College Edition, get a Black's Law Dictionary, preferably a 4th, 5th, or 6th, and a current 9th. A little bit on a U.C.C.B book, and a contract book. Those are at least some fundamentals for you to get a grasp of this. Now, who are you? And you have to really get this down. When this body dies, is it not true that there is a spirit inside here? For those of you that believe in God, that when this body dies, there's a spirit and it goes someplace. Are we in concert with that? So, in reality, is this me? Or is it the spirit inside this body is me?
Are you sure it's inside?
Well, that's a good question, too. But this body is not me, is it? I'm the spirit. So if I ask you who you are, just like God answered to Moses, I am that I am. I'm me. If I want to know how you're called, I might say, what is your name? Or what is one of your names? Usually a judge just wants to know your name. Needs you to identify this body, this collateral.
What are the purpose of names?
What is the purpose of a name?
Anyone have an idea of what the purpose of names are in commerce? To differentiate. Why would we want to differentiate? Well, why? Why do I need to get this? Liability, one reason.
The name binds you to a contract.
Titles, right? Rights, interest. So you have liabilities, duties, titles, rights, interest. That's what gets associated with a name. Okay, you've heard of people just making distinction between the all uppercase name and the upper and lowercase name. Are you either of those? They're just two different forms of title, of identifying interest, of identifying liability.
Also referred to as an appellation or a calling out. How many Brandons, how many Gordons, how many Jacks are there?
And in fact, in commerce, a private trust is a natural person. Look up natural person in your law dictionary. Because only a natural person can contract to create a public trust. What does that mean? It means there was a private trust first. That the public itself is created out of trust. Out of private contract came the public contract, the public trust. So, private contract is the highest form of law. So you want to know, well, how is it we can do these things? Because you say so. Because you have the capacity to contract privately. Nobody can stop you from contracting. No one can impede your rights to contract. And it was private contract that created the government itself. So the government is a result of private contract. And it cannot impede another private contracts. In fact, it can't recognize private contracts. That's why when you go into a court trying to be the private trust, they can only recognize the public trust. My battery's dead.
Here.
The battery's dead.
So let's go forward with your thought.
What we're doing is showing you that if you're lost, the first thing you have to do is orient yourself. What direction do we see the orient as in? The east. But yet in Scripture it says to go west. So you go to the orient, which is east, and does the public really end up explaining who you are? The public doesn't tell you the truth. So where direct you to the east for orientation, but when you get there, you do not have the truth. You look up the reality in West Publishing, the law publishers books. Public's always bad.
You know, Brandon's talking to you about contracts. It is said that all law emanates from contract or agreement. Therefore, contract is law and law is contract. Or stated another way, contract equals law and law equals contract. Consent makes the law. So we encourage you that whenever you see the word law, you substitute contract, and it's going to help you to understand what you're dealing with. But also understand, and you have to stop and think for a minute. Quit reading all the books and all stuff. Say, stop and think, what would bind all of us together? What gives me the right to be over Brandon or Jack? Or this police officer, or this senator, or this congressman over you? Consent makes the contract. What contract? If you're on the highway, some of you are talking about driving down the highway and wanting to use this commercial process to preclude a policeman from getting in your face too much or giving you a ticket. But you have to start out with the fundamental contracts. Whose car are you traveling in? Or driving? I don't know which one you're doing. You may be traveling, you may be driving. But if you have a state car or a car that has a state plate on it, it's their car. And therefore, you're required some kind of a license. So when you start arguing with that police officer, which has its advantages and disadvantages, you will have heard on my recent Monday night, we had Brandy on there, and he talked about he has no plate on his car at all, and he's all the time getting dealt with the police department. I said, why don't you put a private plate on it and identify it? Otherwise, it's merely a pirate on the Sea of Commerce. He could preclude, but he's kind of having a lot of fun. He's doing some really interesting things with it. But Brand is talking about contracts. Let's keep focused on that. The Constitution in Article 1, Section 10, Clause 1, in pertinent part states that no state shall pass any law impairing the obligation of contracts.
And now, I want to make a distinction there. Your rights do not come from the Constitution. Is everybody clear on that? You don't need the Constitution. The Constitution limits what the government can do. They cannot impede your contracts. The Constitution didn't give you the right to contract. You have that, it's an inalienable, God-given, absolute right.
Yeah, where do your rights come from? Those that quote the Constitution are in big trouble because you weren't a party to it. That document limits the federal government by the 17 enumerated powers in Article 1, Section 8. Then you say, how does the government do all the stuff they do now? Well, understand, it's a de facto government in a democracy. De facto, existing in fact, but not legally established. Well, that's not right, is it? Sure it is. All these people in America have every right. Every one of you sovereigns, which is nothing more than authority, every one of you creditors, every one of you secured party creditors, every one of you are creditors. That's why you're able to enter into a contract. That contract can be part of the democracy where you give up you can't give up your unalienable rights. They are always there. They're not unalienable, not in an alienable condition. They're God-given, and the only one that can take them is God. But you can't contract them away. And in this world out here, we have two forms of government. We have the republic, which is, in its simplest form, is a limited democracy, limited by the 17 enumerated powers in Article 1, Section 8 of the Constitution. And that is an agreement among the states. When they say we the people, they're not talking about individuals out there. We the people as representatives of the state. And you can find that elucidated in detail by Abel P. Upshur on a treatise regarding the federal government, which is just phenomenal. So in this thing called contracting, understand that you are the ultimate authority. Your problem What is your problem?
I don't have a solution.
But if you had a problem, what is your problem? Is it not you? Your problem, ladies and gentlemen, and we'll talk about this, and we have such good stories to tell you regarding it, so that you can remember some parables, if you will, not parables so much as stories of examples of people that have just given it up all the time. Believe it or not, Brandon has a wonderful story. I have some. Jack has some that happen to each of us personally, as well as many of our students. You're going to find that you are the law. Out here in this democracy, 300 million people existing in this society have the right to choose a democracy. And then there's a very small few which have a right to choose the republic. Really, everybody does, only a small few. I'm on the plane, I'm sitting with somebody, and we're talking about republic democracy. I said, I'm sitting in the republic, you're in the democracy. You think you're John, I think I'm me. All sorts of little nuances. But once you get this down, you're going to find that you have the power. Consent makes the contract. Then we're going to have to talk about it a little bit, because Brandon is going to show you, and Jack's going to show you in depth how to get a contract. At least a parole contract, which can be either written or oral. But once you've got that, how are you going to keep it? That's many of everybody's problem. You can come here to these seminars, be taught how to efficiently obtain an agreement or contract, if you will. But how do you hold it? But more important, how do you give it up?
Let's back up for a second. Gordon's right. Everything's contract. But we know under contract law that certain people do not have the standing or capacity to contract.
Like who, Jack?
Those who are incompetent.
What do you mean by incompetent?
Incompetent means that they don't know who they are and what they're doing.
I heard incompetency was not capable of handling one's own business.
Correct. And so the real question is, what binds us all together? That was the most fundamental question, to which the answer is contract. But what really binds us together is being your brother's keeper. And so if your brother doesn't know how to contract, what binds us together then is necessity to protect your brother.
You're not talking democracy here for a moment?
The majority of the problems everybody has is they think they're competent and they can go out and handle their affairs. And they run up against someone that is a higher level of understanding in what we call the government.
Put it in a little more simple terms for me.
They won't let you get your way. And the reason they won't let you get your way, and you're saying, but Gordon told me I have the right to contract. You do have the right to contract if you're competent enough to know how to contract, because you are protecting your brothers. When you contract, in which you want to take something away from your brothers, or it's all about what I'm going to get out of it, not what I'm doing for someone else, you've demonstrated that you're incompetent. And when you're incompetent, somebody is going to prohibit you from contracting.
So you're saying,
and that's when you get frustrated.
If I try and take this process of administrative process on, and not using good faith, which I heard that good faith is imputed into every contract.
It's not that they can prevent you from contracting. It's that by the nature of your contracting, you're voiding your own contract. You're creating
Wait, what?
a non-executable contract.
Explain that in a little more detail. You lost me.
We were actually, one of the things I want to go into are some of the maxims of law. Maxims of law are, if you look up a maxim, it's an axiom. It is a self-evident truth.
Okay. I was curious what it was.
The Bible is basically the foundation of Western law. Okay? You'll find a Bible in every courtroom. And in the Bible, you will find the maxims of law. And maxims of law, like you've heard, how many of you have heard silence is agreement? You heard that? Why is that so? Anyone know why that's a maxim, that's an axiom, that's a self-evident truth? How is that a self-evident truth?
Wait, what'd you say?
Silence is consent or agreement.
Seems
But how, okay, now that's a judgment, right? Disrespectful? That's my opinion. I consider it. Okay, so what makes it a self-evident truth that silence is agreement or consent? It was not rebutted. How can it be presumed that it's against, that you're, how can I presume that you're not in agreement if you have not expressed that you're not in agreement? I can only presume you're in agreement because there was no expressed refusal or rebuttal. That's why that maxim of law is a self-evident truth. When you start forming contracts that violate these self-evident truths, the contract's void. It has no force and effect. So there are certain elements that must be present in order for it to actually be a contract. There must be parties. And you hear a lot of patriots, they'll go in there and they refuse to take any kind of responsibility in connection with the contract. So there's no contracting party there. And if there's no contracting party, no contract. So you have to understand that your conduct in all of your affairs determine whether or not there's a contract. And that's why so many of these patriots in court are getting Ferretti hearings.
Hold on. You said conduct. I mean, does that mean more than words?
It means a lot more than words. Your actions, signs, everything.
Kind of give me an example of what you're talking about.
For example, if I say, sit down over there, and you sit down over there.
So you're the judge. So you're the judge of the
It doesn't
bailiff.
matter whether I'm a judge or bailiff. If I just say, well, you sit over here, we've created a contract. Okay, there's a relationship, and by your conduct, you've established a rapport with me. Great example.
Wait a second. I'm just a team secretary. Go slow down.
Okay.
So if somebody tells me to do something and I do it, I've established a contract essentially.
You've established an understanding, which is the basis for. See, a contract has elements in it, and within the contract there can be multiple agreements. Many people think that an agreement and a contract are synonymous and are the same thing.
So you're saying that within a contract, an agreement is just the terms and conditions of a contract. So a contract's the entire agreement of the parties.
It not only does it include the agreements of the parties, which could be multiple agreements.
So multiple agreements. Sit over there, do this, and I might change it, it might change, go back and forth. And that's what's going to, all these different agreements will constitute what we call a contract.
Plus the duties that are created by the agreements, the liabilities,
Yes.
The performance itself is part of the contract.
So the contract really speaks to the whole thing,
The whole thing.
as opposed to agreements, which might be just pieces of the contract.
Of the contract.
Okay, I need that kind of.
Yeah, and actually if you go into the U.C.C., the U.C.C. does a beautiful job of making a distinction that contract is not agreement and agreement is not contract. That a contract may have several agreements within it, but a contract will also include the duties, the performance, the liabilities, anything that is created as a result of the many agreements that go into a contract. For instance, a contract could be, I want to hire this gentleman to come repair my roof, right? So I agree to pay him $2,500. He agrees to repair my roof. And now, that is just the expressed part of the contract. What's implied?
Good work,
Good faith in the contract.
do a good job, those kinds of things. Completed,
It's probably implied that he's not going to do any further destruction in my house. Right? It's probably implied that I'm going to pay him
Wait a minute.
in some
So
form.
implied, so contracts are express or implied, So when I might make an agreement or a contract with someone, I might verbalize, express something, but then there's all sorts of, you're talking about implied. What do you mean implied?
Implied is, again,
Unspoken terms and conditions you
unspoken.
understand it to be?
It could be conduct, it could be your understanding in the agreement, the intent of the parties. This is going back to maxims. I love this, one of my favorite maxims of law, and this is right out of Bouvier's. The intention is the soul of the instrument. Meaning, an instrument can be a written agreement, it could be a negotiable instrument, some kind of a bond showing evidence of debt, but anything that facilitates the performance of a contract can be considered an instrument. And the intention behind it is the soul, meaning it's not the expressed words in the document that are the nature of the document. Meaning, you've heard, like, if you meant for the contract to mean one thing, but the way that you wrote it out, it was construed and interpreted as something else. This is when the conduct becomes so important in the contract. I watched an episode of Judge Judy. Anyone ever watched Judge Judy? And the two parties come in, one was a landlord, one was a tenant. And the landlord wanted back rent from the tenant. And they had an expressed written lease agreement where the tenant agreed to pay, in the document, $2,000 a month. But from month one, the tenant only paid $1,800 or $1,600 a month for 6 or 7 months. And now this landlord was attempting to get the tenant evicted for not paying this back rent. And the tenant's position was, my rent was $1,600 a month. I've paid. I'm in honor with the contract.
Wait.
And Judge Judy says, well, first the landlord wants to argue and wants to show, here, Judge Judy, this is the contract he signed. It's got his signature on it. Okay? Judge Judy looks at it. Is this your signature? Yes, Your Honor. Okay? She then asks him, what was your understanding of the contract? Well, I understood that I was going to be paying $1,600 a month. I didn't